Let me ask you something right now. If you are a green card holder and you are planning to travel outside the United States this year, do you know the new rules that went into effect just in the last few months? Because here is the truth. The landscape has changed dramatically, and what you do not know could cost you your green card, your ability to re-enter the United States, or both. Today, on Immigration News. Today, we are going to walk you through everything you need to know about the sweeping new travel rules hitting green card holders in 2026, what they are, why they matter, who is most affected, and exactly what you need to do before you book that next flight. Stay with me through this entire video, because every single section contains information that could protect you and your family. And if you find this valuable, please hit that subscribe button, because we put out daily updates on immigration news, travel rules, and government policy changes that affect you and millions of people just like you. Let us start at the beginning, because understanding where we are requires understanding what happened and why. Over the past several months, the United States government has introduced a series of overlapping changes that together represent one of the most significant overhauls of travel and entry policy for lawful permanent residents in recent memory. These are not rumors, they are not speculations. They are official policy changes backed by presidential proclamations and Department of Homeland Security directives. So let us break them down one at a time, clearly and calmly, so you leave this video fully informed. The first major change you need to understand is the mandatory biometric photographing of all non-citizens at every single border crossing. I want you to hear that clearly. Beginning December 26, 2025, U.S. Customs and Border Protection, CBP, began photographing all non-U.S. citizens, including green card holders, every time they enter or exit the United States. This applies at airports, land crossings, and seaports. And here is something that surprises a lot of people. The previous age-based exemptions that used to apply to children under 14 and adults over 79, those exemptions have been removed. Everyone is subject to biometric screening now, regardless of age. What does this mean practically? It means that when you arrive at a U.S. port of entry as a green card holder, a CBP officer will take your photograph, and that image will be run through a facial recognition system that compares it against existing records held by DHS, the Department of State, and CBP itself. This is part of a broader biometric entry-exit tracking system that Congress actually mandated back in 1996, but that has been slowly rolling out over the years. The current administration has now accelerated its implementation significantly. CBP systems are also building galleries of biometric images associated with individual travelers, essentially a digital trail of every time you enter and exit the country. Now, for most green card holders with clean records and current documents, this process will be a routine inconvenience rather than a major obstacle. But here is where it gets serious. If there are any discrepancies in your records, a name that does not match perfectly across documents, an outdated address, a prior travel issue that was never fully resolved, the facial recognition system and heightened secondary inspections can trigger a much more intensive review of your file. Immigration attorneys are already advising clients that this new digital integration between DHS, USCIS, and other federal agencies creates far more data points through which your full history becomes visible the moment you step to that border. The advice is simple. Make sure every document you carry is current, consistent, and complete. We will talk about exactly what that means in a moment. Now let us talk about the expanded travel ban that went into effect on January 1st, 2026, because this is the change that has sent shockwaves through the immigrant community, and there is a lot of confusion about who it actually affects. On December 16, 2025, President Trump issued a presidential proclamation titled, "Restricting and Limiting the Entry of Foreign Nationals to Protect the Security of the United States." This proclamation dramatically expanded the earlier travel restrictions that had been put in place in June 2025. The new ban now covers nationals from a total of approximately 39 to 40 countries, either under full or partial visa restrictions. Under full restrictions, nationals of 19 countries are completely barred from receiving both immigrant and non-immigrant visas. These include Afghanistan, Burma, Chad, the Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Libya, Somalia, Sudan, and Yemen, among others. An additional set of countries faces partial restrictions, meaning certain visa categories are suspended or face heightened scrutiny. Here is the question I know you are asking right now. Does this travel ban apply to me if I already have a green card? And the answer, under the current proclamation, is no. Green card holders, lawful permanent residents, are explicitly listed as exempt from the travel ban restrictions. So if you are a green card holder who is a national of one of the affected countries, the ban as written does not strip you of your right to re-enter the United States. That is important to understand and to carry with you. However, and this is a critical however, being exempt from the travel ban does not mean you are exempt from heightened scrutiny at the port of entry. It does not mean your pending applications are unaffected, and it does not mean the rules cannot change between now and when you return from a trip abroad. Let me explain that last point further, because it is one of the most important things you will hear in this video. USCIS has confirmed that it has suspended adjudication on a wide range of immigration benefit applications for nationals of the affected countries. That includes adjustment of status applications on Form I-485, green card renewals on Form I-90, removal of conditions petitions on Form I-75E1, applications for re-entry permits and travel documents on Form I-131, and naturalization applications on Form N-400. What this means is that even though your existing green card protects your right to return, if you are in the middle of any renewal or application process, that process may be frozen or significantly delayed. If your green card is expiring soon and you are a national of one of these countries, you need to consult with an immigration attorney before making any international travel plans. Traveling while a critical application is in limbo is one of the most common mistakes that can turn a routine trip into a nightmare at the border. Now let us talk about what the travel rules mean specifically for green card holders who are not nationals of any banned country, because the changes we are discussing do not only affect people from those 39 nations. The heightened biometric screening, the enhanced secondary inspections, and the overall stricter environment at ports of entry affect every single non-citizen entering the United States. There is a well-established legal principle that CBP officers are careful about with green card holders, what is called seeking admission. Under the Immigration and Nationality Act, most green card holders returning from routine trips abroad are not treated as though they are seeking admission from scratch. They have stronger protections than visa holders or tourists. However, there are specific circumstances under which a CBP officer can determine that a green card holder should be treated as seeking admission again, and that subjects them to a much more intensive review. Those circumstances include traveling abroad for more than 180 continuous days, which can raise questions about whether you have abandoned your U.S. residency. They include committing certain crimes before or during a trip abroad. They include abandoning your ties to the United States, not maintaining a U.S. address, not filing U.S. taxes, not maintaining employment or family connections here. And under the current enforcement environment, with much more robust data sharing between federal agencies, CBP officers are better equipped than ever before to identify green card holders who may fit one of these categories. The simple message here is this: if your green card is your home, treat the United States like your home. Maintain your address here, file your taxes here, keep your green card valid, and do not stay abroad for extended periods without a re-entry permit. Let us talk about what a re-entry permit is and when you need one, because this comes up constantly in our community. A re-entry permit is a travel document issued by USCIS that allows a green card holder to remain outside the United States for up to 2 years without abandoning their residency. It is filed on Form Y-131, and you must apply for it before you leave the United States. You cannot apply from abroad. If you know you are going to be outside the country for more than 6 months, whether it is for family caregiving, medical reasons, business, or any other purpose, apply for that re-entry permit first. In the current environment, with USCIS processing times already under pressure, and with adjudications of certain applications being suspended, the importance of planning ahead has never been greater. Now here is something else I want you to understand clearly, because it is one of the more nuanced aspects of the current rules. There is a difference between being outside the United States for an extended period and what is called abandoning your green card status. No single trip of under 1 year automatically triggers abandonment, but the longer you are away and the fewer ties you maintain to the U.S., the higher the risk that a CBP officer will challenge your intent when you return. And in this current enforcement climate, those challenges are more likely to result in secondary inspection, a formal interview, and potentially a referral to an immigration judge. If CBP believes you have abandoned your residency, they can issue you a form called I-407, which is a record of abandonment, and ask you to sign it. You are not required to sign that form. Never sign any document at the border that you do not fully understand. Politely ask to speak with a supervisor, and if possible, contact an immigration attorney before making any decisions. Let me walk you through the practical checklist of what you should do right now, today, if you are a green card holder who travels internationally. First, check the expiration date on your green card. A green card that is expired or expiring within the next few months needs to be addressed immediately. File a renewal application using Form I-90 without delay. Second, make sure your address on file with USCIS is current. USCIS sends critical notices by mail, and missing a notice because you moved without updating your address can have serious consequences for your immigration status. You update your address with USCIS using Form AR-11, and it can be done online at the USCIS website. Third, if you are planning travel of more than 6 months, consult with an immigration attorney about obtaining a re-entry permit before you leave. Fourth, gather your supporting documents. When you return to the United States, you should be able to demonstrate your ties here. Employment records, lease or mortgage documents, bank statements, utility bills, and anything else that shows the United States is your home base. Fifth, if you are a national of any of the countries listed under the expanded travel ban, consult with an attorney before any international travel, even short trips, given the heightened scrutiny you may face. Now I want to address something that has caused a great deal of anxiety in the community, and I want to be as clear and as calm about it as I can be. Some green card holders have seen reports about USCIS reviewing the green card status of immigrants from certain countries and have worried that their green cards could be revoked while they are abroad. Here is what we know as of today. USCIS has indicated that it is reviewing immigration applications for nationals of the 19 originally flagged countries with heightened scrutiny, treating nationality as a significant factor in the assessment. Legal experts and advocacy organizations have raised serious concerns about this approach, and litigation is ongoing in several cases. The current proclamation and DHS guidance do not authorize mass revocation of existing green cards from lawful permanent residents. Your green card, once issued, carries legal protections. But the broader environment makes it more important than ever to stay informed, to keep your documents current, and to have access to qualified legal advice when you need it. I also want to mention a change affecting the cost of certain filings. As of January 1, 2026, USCIS implemented inflation-based fee adjustments for several immigration categories. This affects asylum-related filings, certain parole applications, temporary protected status requests, work authorization applications linked to those categories, and travel programs like ESTA and EVAS. If you are filing any of these categories this year, check the USCIS website directly for the updated fee schedule before submitting. Sending an incorrect fee amount is one of the most easily avoidable reasons for a filing rejection. And in the current processing environment, a rejection means starting the clock over. Let us take a step back for a moment and talk about the bigger picture, because I think it is important to understand the context in which all of these changes are happening. The current administration has been consistently signaling a security-first immigration framework that prioritizes intensive vetting, broader data collection, and tighter enforcement at every stage of the immigration process. This includes expanded social media screening for certain visa applicants, biometric exit tracking, enhanced scrutiny at consular interviews, and stricter residency checks for green card holders. The landscape is evolving rapidly, and it is being reviewed at regular intervals. The proclamation itself requires a review every 180 days. That means the list of affected countries, the scope of restrictions, and the specific exemptions can all change. What is true today may be different 6 months from now. That is not a reason for panic. It is a reason for vigilance. For those of you who are in the process of applying for naturalization, this is also a moment to think carefully about timing. Becoming a U.S. citizen is the most complete form of protection from immigration-related travel restrictions because U.S. citizens are not subject to the same re-entry rules, the same green card maintenance requirements, or the same border scrutiny as lawful permanent residents. If you are eligible for naturalization, generally 5 years as a permanent resident, 3 years if you obtained your green card through marriage to a U.S. citizen, this is a very meaningful time to consider moving forward with that process, provided your case is eligible and the adjudication has not been placed on hold due to your country of origin. Talk to an immigration attorney about your specific timeline and eligibility. Before I close, I want to remind you of something that I believe deeply and that drives everything we do on this channel. Navigating immigration policy is not easy. It never has been, and right now it requires more attention and more care than perhaps at any point in recent years. But knowledge is your most powerful tool. The more clearly you understand the rules, the more confidently you can make decisions, protect your status, and plan your future. You are not alone in navigating this. There are qualified immigration attorneys, accredited representatives, nonprofit legal aid organizations, and community groups across the country that can help you understand your specific situation. And every single day, we are here at Immigration News Today to bring you the updates, the context, and the plain language explanations that help you stay ahead of these changes. Please remember that the information in this video is current as of February 18, 2026. Immigration policy is subject to change, and new guidance, litigation outcomes, or executive actions could alter any of the rules we have discussed. Always verify your specific situation with official government sources, particularly uscis.gov, dhs.gov, and cbp.gov, and consult with a qualified immigration attorney or accredited representative for advice tailored to your personal circumstances. This video is informational and educational in nature. It does not constitute legal advice, and no attorney-client relationship is formed by watching it. If this video helped you, please give it a like, share it with someone in your community who needs to know this information, and subscribe to Immigration News Today so you never miss an update. Check the description below for links to official resources and guidance that can help you take the next steps. We will keep watching, we will keep reporting, and we will keep making sure that you have the information you need to protect what you have worked so hard to build. Take care of yourselves, stay informed, and we will see you in the next video.